We're about to get started. Thank you all so much for being here. And thank you so much to Professor Bustos for joining us. We're really excited to have you. My name is Naomi. I am the Litigation and Program Fellow at the Law, Environment, and Animals program. And thank you all so much for being at our final speaker event of our fall speaker series. So before we get started, I wanted to make a few quick announcements. First of all of the food that you are eating is vegan, including the cookies. Second, there will be time for a Q&A following Professor Bustos' talk, so please hold your questions until the end. We are also recording this event. We'll post the first part of the talk, the presentation, but the Q&A will not be posted anywhere, so please speak freely. And then finally, we would like to extend a massive thank you to our co-sponsors for their support and collaboration. Thank you to the Yale Animal Law Society, Yale Environmental Humanities, the Yale Environmental Law Association, Plant Forward Yaleys, and the Yale Sustainable Food Program. With that said, thank you all for being here. We are so excited to have you here today. Camila Bustos is an assistant professor at the Elisabeth Haub School of Law at Pace University. Prior to joining Pace, Professor Bustos was a visiting assistant professor of human rights at Trinity College and a clinical supervisor in human rights practice at the University Network for Human Rights. She also served as a term law clerk to Justice Stephen D. Ecker of the Connecticut Supreme Court and as a consultant with the International Refugee Assistance Project, IRAP. Professor Bustos is a graduate from Yale Law School, where she received the Francis Wayland Prize and was a Switzer Foundation Fellow and a Paul and Daisy Soros Fellow. During law school, she worked at the Center for Climate Integrity, the Climate Litigation Network, and Earth Rights International. Professor Bustos also co-founded Law Students for Climate Accountability, a national law student-led movement pushing the legal industry to phase out fossil fuel representation and support a just, livable future. Prior to law school, she worked as a human rights researcher at the Center for the Study of Law, Justice, and Society, de Justicia, in Colombia. Professor Bustos' writing has appeared or is forthcoming in the Vanderbilt Law Review, Harvard Environmental Law Review, NYU Environmental Law Journal, the Connecticut Law Review, and the Yale Journal of Law and Feminism, among others. Her research and scholarship focuses on human rights and environmental law. She is a frequent presenter on climate displacement, climate law, and environmental justice, and has provided expert testimony before the Canadian Senate and the Inter-American Court of Human Rights. She serves as a board member of Law Students for Climate Accountability and Save the Sound. Thank you so much for being here. Thank you.
Good afternoon, everyone. It's a pleasure to be here, particularly because it was here as a student walking through these halls that this project that I'm about to present really came to be. But before I begin, I want to thank the Law, Environment, and Animals program for the kind invitation, Naomi for moderating today's session, and of course, Doug Kaiser, who's just been an incredible mentor and deserves no introduction. Perhaps, as some of you, I went to law school to dedicate my career to public interest work. My first semester, Yale Law Women invited a high-profile executive at ConocoPhillips as a guest speaker. A few of us organized a protest outside the room where we held signs and passed out small flyers containing information on the climate crisis and the role of ConocoPhillips and other fossil fuel companies in decades-long campaign of deception. The following year, several students at Harvard, NYU, Michigan, and Yale protested Paul Weiss and other law firms representing fossil fuel companies. These experiences really shaped my own thinking about the role of law and elite spaces such as this one in legitimizing careers in the legal profession that perpetrate climate harm. It also eventually led to the creation of Law Students for Climate Accountability, a student-led organization that seeks to amplify the roles and responsibilities of the legal industry in driving climate change. More than 7 years later, it's an honor to be back here to present my article representing climate wreckers on the intersection of legal ethics and climate change. But before I begin, I'd like to share some facts to set the context for our conversation today. 2024 marked the hottest year on record. Scientists warned that this is the first calendar year that the Earth has exceeded the 1.5 degrees Celsius warming limit. Law firms, of course, play a central role in upholding our current infrastructure. Attorneys review contracts, engage in transactions, and often conduct lobbying on behalf of fossil fuel interests. According to the 2025 Climate Change Scorecard, from 2020 to 2024, Vault 100 firms engaged in more than 600 representations exacerbating climate change, earned over $35 million for lobbying on behalf of fossil fuel interests, and facilitated over $2 trillion in transactions supporting fossil fuel work. Work exacerbating climate change still vastly exceeds climate mitigating work. In litigation, more than 88% of all cases that we studied involved firms promoting fossil fuel interests. And compensation received for lobbying on behalf of fossil fuel interests is still double the compensation for renewables lobbying. With this context in mind, my research raises two questions. First, what is the role of lawyers in thinking about a just transition away from fossil fuels? And second, how do existing regimes adapt or should adapt in the context of climate change? Now, at the heart of this inquiry is a fundamental tension in legal ethics. On one hand, the principle that everyone deserves representation is a fundamental value in our legal system, closely tied to notions of due process, access to justice, and the adversarial system as a whole. On the other hand, we have lawyers' duty to the rule of law itself, and climate change represents an existential threat not just to society, but to the legal institutions and frameworks that make law possible. The dominant approach to attorney ethics in the US and in many jurisdictions is to treat lawyers as neutral service providers. Under this view, lawyers should not be held morally accountable for their clients' actions, provided that lawyers stay within the bounds of professional conduct and, of course, the law. In this manner, we may consider ordinary ethics or ordinary morality very different than legal ethics. And there are good reasons for this. First, we want everyone to be able to access legal counsel, regardless of whatever claim or charge they're facing. And access to counsel is an essential part of accessing justice and the whole legal system more broadly, which in turn requires you to have a lawyer to stand a chance in the adversarial system. Second, we want to insulate attorneys from potential backlash of representing controversial clients precisely so they can ensure that they can access a lawyer. And again, this idea is not new. It goes back all the way to the common law in England, where the cap rank rule, which I'll briefly discuss in a moment, emerged to really protect lawyers representing controversial clients who the king didn't particularly like. Now, in the context of civil matters, I argue that this approach distorts foundational legal principles and actually allows attorneys to remain unaccountable vis-a-vis the public and those at the forefront of the climate crisis. The notion that everyone deserves representation, while crucial in many contexts, becomes problematic when invoked as a blanket justification for enabling the very actors who are undermining our collective future. My article challenges the idea that lawyers representing climate wreckers are simply fulfilling their professional duties. Instead, I argue they're making an affirmative choice that warrants serious scrutiny. But before we go further, I want to be precise about who I mean when I use the term climate wreckers. You may have heard this term before, or even climate villains, but the term climate wreckers comes from UN Secretary General António Guterres, who in 2022 urged recent graduates to use their talents to create a renewable energy future rather than to work for what he called climate wreckers. I am borrowing and elaborating on this term to refer specifically to fossil fuel corporations and trade associations that have engaged in public disinformation campaigns to stop climate action and sow doubt regarding climate science. This is not a term I apply lightly or broadly to all corporations that contribute to emissions. I identify 3 features that distinguish these actors and justify treating them differently. First, the scale of climate disruption caused by these companies is unprecedented. Groundbreaking research by Richard Keating and others identified 90 companies, termed the carbon majors, who are responsible for 2/3 of atmospheric CO2 and methane emissions between 1751 and 2010. Nearly 1/3 of these emissions can be traced to just 20 private and national companies. What's particularly striking is more than half of all industrial emissions of CO2 have occurred since 1988. Let me repeat that. More than half of all industrial emissions of carbon dioxide have occurred since 1988. Since 1988, after the establishment of the Intergovernmental Panel on Climate Change, or IPCC, after leading scientists had publicly stated that emissions drove climate change, and after vigorous public discussion of its causes and risks was well underway. These companies knew exactly what they were doing, and they did it anyway. Second, we now have documented evidence of deliberate deception. As early as the 1950s, scientists understood the role of greenhouse gas emissions in trapping heat in the atmosphere. Internal fossil fuel industry memos show how companies like Chevron, Exxon, Peabody Energy, and others intentionally deceive the public about the threat posed by climate change. For almost 3 decades, these companies distorted scientific findings and blocked efforts to adopt legislation to transition away from fossil fuels. The parallels to big tobacco tactics are striking and deliberate. These companies could have planned to transition away from carbon-intensive models, but instead they chose to use deception to continue exploring, producing, and marketing their products. Third, like many other sources of environmental harm, the emissions from these companies are traceable. Attribution science has advanced to the point where we can now link specific extreme weather events to anthropogenic climate change and therefore allocate shares of responsibility for specific climate impacts to particular companies. This traceability distinguishes climate wreckers from other actors whose environmental contributions may be more diffuse or harder to quantify. So how do our current professional responsibility rules address this situation? The short answer is they don't, at least not adequately. The model rules of professional conduct, which have been adopted in some form by all jurisdictions within the United States, embody a view of lawyers as neutral agents who can remain morally not accountable for their clients' actions. Model Rule 1.2 explicitly states that a lawyer's representation of a client does not constitute an endorsement of the client's political, economic, social, or moral views. The commentary to this rule explains that legal representation should not be denied to people whose cause is controversial or the subject of popular disapproval. While lawyers may consider moral, economic, social, and political factors while providing advice under Rule 2.1, they are not required to do so. In practice, this framework facilitates what my colleague Professor Kim Q has called malignant normality, where legal professional norms frustrate an effective response by the profession to climate change. Results from a survey of corporate finance lawyers working at global law firms in London found precisely this. Respondents demonstrated disturbingly high levels of apathy toward the potential social or environmental impacts of the services they provide. Respondents claimed it was not their role to judge what their clients did, and that therefore they should not be held accountable for their clients' actions. When lawyers distance themselves from the ethics of their work in this way, it becomes easier for them to ignore ethical considerations when they're furthering questionable objectives. The survey responses indicate that these lawyers seem to have never really entertained the idea that they could actually do something about how law is practiced in the first place. This, of course, reflects the dominant conception of lawyers as zealous advocates who owe special duties to clients and can remain neutral and non-accountable. Under this view, individual lawyers and their clients do not have to concern themselves directly with ideas of justice or the public interest, because the adversarial system as a whole is going to produce just outcomes in the aggregate. This brings us to what I consider a critical distortion of legal ethics principles: the invocation that everyone deserves representation as a justification for representing climate wreckers in civil matters. This argument fails on multiple levels when we examine it closely. First, there is no legal duty in the United States for lawyers to represent any particular client absent a court appointment. As the restatement 3rd of the law governing lawyers makes very clear, a lawyer is not required to accept a client or to undertake representation without pay, except again when a court has appointed the lawyer. Lawyers have wide discretion in choosing whether to accept instructions. So when attorneys represent climate wreckers, they're making affirmative choices to do so, not fulfilling just some professional obligation. The right to counsel, of course, applies to criminal defendants facing the power of the state, a potential loss of life or liberty. It does not create a constitutional right to retain a specific lawyer or law firm, nor does it suggest that any individual lawyer or firm's refusal to represent a specific client is of constitutional significance. Moreover, the right to counsel is an obligation of governmental authorities, not of individual lawyers. Extending this principle to well-resourced corporations in civil matters distorts its fundamental purpose. Second, let's consider market reality. And I don't have to tell you about that because you know how much big law pays. Fossil fuel companies are among the most well-resourced entities on the planet. They can afford in-house counsel and often retain multiple law firms simultaneously. The idea that these companies would be foreclosed from accessing legal representation if some lawyers decline to represent them is simply not credible. The common retort that, if not me, then someone else will do it, actually proves this point. Given the high legal fees and profits involved in multi-million-dollar contracts, it is virtually impossible, at least under capitalism, that no lawyer would represent climate wreckers. Law firms respond to logic in the market, and the financial incentives here are too strong. This is not a situation where unpopular defendants are struggling to find counsel. This is a situation where well-heeled corporate clients have their pick of the most prestigious and skilled attorneys in the world. Third, we must acknowledge massive power asymmetry at play. While fossil fuel companies enjoy first-class access to the legal system, communities most harmed by fossil fuel extraction and climate change can rarely access legal representation. The vast power imbalance between those who have enabled a crisis and those who are feeling the impacts most severely reveals that everyone deserves representation argument is a legal fiction that obscures the real dynamics at work. I now want to turn to a quick comparative law point. Because in England and Wales, this debate has taken some interesting dimensions. Unlike the US, the British cap rank rule presents a doctrinally divergent path. Lawyers are required, under this rule, to represent anyone that seeks their counsel. In particular, the rule prohibits barristers from refusing to represent any client under certain circumstances, but it does not apply to solicitors. As background, England distinguishes between solicitors, who primarily handle client relationships, initial legal advice, and pretrial or pre-hearing work, while barristers specialize in courtroom advocacy and are typically hired by solicitors to argue the case. This division, of course, does not exist in the United States, where lawyers generally perform both roles. Now, this is significant because barristers are typically instructed by solicitors, meaning solicitors have already chosen to represent the client. So the cap rank rule only becomes operative when a person already has legal representation from a solicitor who chose that client freely because they're not bound by the cap rank rule. Now, many people, of course, have written about the cap rank rule, and it's been critiqued enormously and deemed virtually unenforceable and riddled with exceptions. Between its limited application and numerous carve-outs, some scholars even consider it to be essentially meaningless in practice. Yet, despite its limited practical effect, the rule is constantly invoked by law firms facing scrutiny for their choice of clients as a rhetorical shield. The situation was tested in 2023, which is what the picture's showing, when more than 120 lawyers in the UK signed a pledge not to act on behalf of the fossil fuel industry, effectively defying the cap rank rule and declaring they would not prosecute climate protesters or support fossil fuel projects through their services. These attorneys then self-refer themselves to the Bar Standards Board for breaching their duty. To my knowledge, none of them have faced consequences, which suggests that even the regulatory body recognizes the limits of the rule's application. Now, what troubles me most is how firms use the language of access to justice to justify their choices and avoid any real engagement with the moral dimensions of their work. Firms love to wave the rule of law around like a flag, assuming it supports whatever particular argument they're trying to make, without seriously examining whether representing climate records actually serves the rule of law or ultimately undermines it. To understand why the current approach is inadequate, we need to examine how scholars and attorneys have conceptualized the proper role of lawyers. We've already talked about the first one a bit. The first one is the most dominant view, and that is a lawyer is a zealous advocate. Under this conception, lawyers should advocate vigorously on behalf of clients, provided that the means and the ends of representation are lawful. The view has its origins in the adversarial structure of adjudication and the idea that zealous advocacy on both sides will ultimately help courts find the truth and reach just outcomes. The idea here is that lawyers who adhere to their institutional role are by extension upholding the legal system. This model presumes that in the aggregate, all of this self-interested behavior is going to result in social benefit. But there are serious problems with applying this model in the context of corporate representation in civil matters. The amorality of the zealous advocate seems excessive and may at times be inappropriate outside the criminal context. When taken to its logical extreme, this approach incentivizes lawyers to resolve ambiguities in favor of their client and to take advantage of every loophole in professional responsibility rules. The second conception is of lawyers as officers of the court, having broader duties to society. Under this view, lawyers are responsible for facilitating the public administration of justice. When there are gray areas that need to be navigated, lawyers should contribute ultimately to the effectiveness and enforcement of substantive law. They should remain independent from clients and unwilling to compromise the integrity of the justice system. Unless lawyers are willing to examine the aggregate effect of their clients' practices on the rule of law, they cannot rely on the legal framework to justify what they do. The third conception, advanced by scholars like Professor Daniel Markovits, sees lawyers as legitimizing agents whose assistance is necessary for clients to pursue their interests through the legal system. Parties who can afford to hire an attorney and seek legal adjudication of a conflict can leverage the legitimizing power of attorneys. But there's a paradox. Powerful parties who deploy the legal process to promote and protect their interests may ultimately undermine the legitimacy of the legal process as a whole. So in the context of climate change, key questions emerge. How can lawyers serve as zealous advocates for clients whose business models threaten the very institutions that make law possible? How can lawyers claim to serve as officers of the court when they facilitate activities that undermine the rule of law itself? Now, some might object that lawyers have always represented controversial or unpopular clients, and that's precisely why we need strong principles of neutrality and non-accountability. But climate change, I argue, is different in kind, not just degree, from past controversies. Judge Staten, in her powerful dissent in Juliana versus United States, observed that the climate crisis is a direct threat to our rule of law, institutions, and legal system. Climate change challenges what she called the Constitution commitment to perpetuity. Climate change threatens the most basic structural principle embedded in our system, that the Constitution does not condone the nation's willful destruction. She noted that civil liberties, as guaranteed by the Constitution, imply the existence of an organized society. The perpetuity of the Republic occupies a central role in our constitutional structure as guardian to all other rights. This is not a hyperbole. Legal institutions were developed under the presumption of stable and predictable conditions. Climate change operates as a destabilizing force. In a planet with erratic climate patterns, rapidly rising seas, and collapsing ecosystems, the liberties protected by the Constitution to live a good life become meaningless. We're not talking about representing someone accused of a heinous crime, where Sela's defense actually protects us all from governmental overreach. We're not talking about advocating for an unpopular political position. We're talking about facilitating corporate conduct that threatens the very possibility of organized society and the rule of law itself. The scale of this threat is also unprecedented. Human activity has changed the atmospheric composition of the planet so dramatically that some geologists have named an entire era after humans, the Anthropocene. Although there are examples of companies harming society through their products, like tobacco and opioid companies, the ultimate effect of those products has not altered the geology of our planet in the same way. So what do we do? Well, I propose that climate change requires a transformation in the practice of law, a paradigm shift in how we think about legal ethics. This shift operates on 3 levels: individual lawyer choices, enforcement of existing rules, and development of new guidance. First, lawyers should normalize declining representation of climate records, particularly when that representation will directly facilitate new fossil fuel infrastructure or increase emissions. The International Energy Agency has made very clear that achieving net zero emissions by 2050 requires no new oil and gas fields. 90% of coal and 60% of oil and gas reserves must remain in the ground. Lawyers should refuse their services when the direct result of representation will run against scientific consensus. Second, we need much stronger enforcement of existing model rules. Rule 3.1 prohibits attorneys from raising frivolous claims or defenses, which should apply to strategic lawsuits against public participation, or SLAPP efforts, and other questionable tactics used to intimidate climate advocates. A recent investigation by The Guardian revealed the extent to which fossil fuel lobbyists orchestrated a campaign to adopt SLAPP legislation against climate protesters. Lawyers who enable this type of intimidation through frivolous litigation should face consequences. Existing rules can also help. Rule 8.4 prohibits attorneys from engaging in deceit and misrepresentation, which should impose limitations on lawyers' ability to support greenwashing. Rule 1.2 prohibits assisting a client with committing fraud or a crime, and Rule 1.16 requires withdrawal when a client insists on using the lawyer's services to commit a crime. Now, the ongoing litigation and controversies surrounding ExxonMobil and other climate wreckers who are facing liability in state courts because of the deception that they committed raise the question of whether the attorneys who were advising those companies adhered to the model rules at the time. The problem, of course, is that most complaints alleging violations of ethical rules are dismissed, and many instances of misconduct go unreported. The self-governing nature of the legal profession and weak enforcement mechanisms remain significant obstacles, not just on climate, but on democracy. Third, jurisdictions should develop new ethical guidance on climate change, building on the groundbreaking work of the Law Society of England and Wales. That guidance recognizes that firms might consider whether to advise on matters incompatible with the 1.5 degrees Celsius and observes that solicitors have wide discretion in choosing whether to accept instructions. The guidance also includes language on greenwashing, observing that marketing materials should not mischaracterize or overstate a firm's climate commitments. In the United States, the ABA or individual states could, hypothetically, develop similar guidance, from general encouragement of climate-conscious lawyering to specific rules prohibiting support for greenwashing and consumer deception. States that have already brought lawsuits against climate wreckers, like Vermont or New York, are well positioned to lead on this front. I want to anticipate and address some objections to this argument. Some will say that I'm simply imposing my own moral views on lawyers, and that such moral activism threatens the pluralism that makes our legal system work. But this critique misses the point. I'm not arguing that lawyers should substitute their moral judgment for their clients in every situation, or refuse to represent anyone whose values they disagree with. I'm arguing that climate change presents a unique threat to the very institutions and frameworks that make law possible, and that facilitating planetary destruction cannot be justified by invoking professional responsibility arguments. Some will argue that this undermines lawyer neutrality and the adversarial system. But neutrality is itself a choice, not a natural or inevitable position. The current approach privileges the status quo and the interests of the most powerful actors. Moreover, in the civil context involving corporate clients, the autonomy arguments that might justify zealous advocacy in criminal defense lose their force. Corporations are legal fictions, not autonomous individuals with inherent dignity. Lawyers representing them are not protecting vulnerable defendants from state overreach, but rather facilitating the commercial interests of the world's most powerful entities. A third objection might be that distinguishing between types of clients or matters is a slippery slope that could lead to witch hunts or discrimination, particularly given the recent attacks by the Trump administration against lawyers and law firms. But I'm not arguing for indiscriminate refusal to represent anyone associated with fossil fuels. The type of representation matters enormously. An attorney helping a fossil fuel company comply with environmental regulations is differently positioned from one helping the same company secure permits for new extraction that will push us past critical climate tipping points. An attorney representing an individual worker at a fossil fuel company in an employment dispute is not the same as one representing the company's lobbying efforts against climate legislation. Let me conclude by emphasizing what is ultimately at stake. Climate wreckers do not lack access to representation. They dominate access to the legal system, while communities most harmed by climate change struggle to find counsel. Current ethics rules, as written and enforced, enable planetary disruption. They create what Professor Irma Russell has called a client-centered paradigm that is fundamentally misaligned with planetary survival. We must interrogate the legal fictions we tell ourselves about neutrality, moral non-accountability, and everyone deserving representation. These principles, which serve important functions in some contexts, become distortions when invoked in others. I'm not arguing that climate wreckers have no right to counsel. I'm arguing that lawyers who choose to represent them should face professional, but especially societal scrutiny for that choice. We need what Professor Bradley Wendell calls moral remainders, sources of reluctance and reflection that ensure lawyers do not operate in isolation from ordinary morality and the existential stakes we face. The legal profession can embrace a paradigm shift where lawyers who hinder a just transition don't have the social license to do so. We can develop accountability mechanisms, enforce existing rules, create new guidance, and most importantly, normalize the act of saying no to representation that is at odds with a stable climate. It's time for lawyers to start declining representation that directly contributes to planetary disruption. The rule of law cannot survive on a dying planet. As Judge stated and observed, the Constitution does not condone the nation's willful destruction. Neither should the legal profession. Thank you.